Let's talk about fees. And Rule 1.5 governs the issue of fees. And the rule says that a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. And Rule 1.5a sets out all of the factors that are used to determine whether the fee should be reasonable. This rule, which became effective January 1st, 2010, has been changed to specifically enumerate that expenses as well as fees have to be reasonable. And if you look at the comments, comment number 1 defines expenses as things such as in-house copying, telephone charges, and faxes. And according to the comment, the price for those charges should either be agreed upon in advance with the client or reasonably reflect the cost incurred by the lawyer. So you might want to consider having a schedule of prices for costs in your fee contracts to alleviate any kind of issue that you may have there. For those of you that do contingent fee work, you need to be aware that all contingent fees have to be in writing, and the writing requires that the client also be informed of their liabilities for expenses. Now, there is no rule that says that all fee agreements have to be in writing, but I would strongly encourage you to put all fees agreements in writing. Why? Because clients are not always the best listeners. You don't want to be in a situation where you have a disagreement with the client about the specifics of a fee agreement. If it's in writing, preferably signed by the client, there's not going to be any he said, she said kinds of issues. And you don't want disputes with your clients. When you're starting out, you want happy clients. Happy clients are going to tell their friends about you, and the opposite is true. Unhappy clients can make your life miserable, and you don't want to start your practice that way. Now, for those of you who split fees with lawyers who aren't in your firms, you need to be aware of Rule 1.5e. This rule says that the client has to agree to the division of fees and has to know that you're splitting fees, and both lawyers have to take responsibility. So if you do referral agreements with lawyers who are not in your firm, your client has to know about that. Okay, let's talk about where fees go. The new rule, Rule 1.15c, specifically recognizes fixed fees. So you can charge a fixed fee for doing a whole case. For example, a criminal case or a traffic case, or for doing specific work such as preparing a document such as a will. If you do charge a fixed fee or a flat fee, it's yours when it's paid, so it does not go into your client trust account. Only money which the client or a third party has interest in goes into the trust account. For example, if you do a case on an hourly basis and the client gives you a retainer up front to be applied to the hours, then that money would go into a trust account because it's the client's money until it's earned, and when it's earned, you take it, you withdraw it. The Rule 1.15, explains the different kinds of retainer agreements, and you need to be aware of that rule if you take retainers other than flat fees. Finally, with regard to retainers and billing, make sure that you send out bills to your client and make sure that those bills are accurate. Send a bill every month. Don't wait until the end of the case to send a bill. Why? Well, first, you look professional if you're sending regular bills every month. Secondly, it shows the client that you're working on their case, and that's what they want to see. So for those reasons, it's a good idea to do it. Also, If there is a dispute or a problem, that can be addressed in a timely manner. If you wait until the end of the case and there are disputes, then nobody's going to remember exactly what happened, and you're much better off just billing regularly. Also, make sure you or somebody you trust in your office reviews those bills so that they're correct. I guarantee you that the client is going to look at that bill closely. They're going to look at every line. And if there are mistakes on the bill, incorrect dates for court appearances, your client's going to notice it and you're going to hear about it. Okay, to recap, get the fee agreement in writing, put the fees in the proper account, bill regularly. If you have questions about fees or retainers, both the ISBA and the ARDC have ethics hotlines where you can call for help. So I would urge you to take advantage of those resources.